Hello, friend. In this childcare law update, we're going to discuss the role of an independent reviewing officer in safeguarding the welfare of children in a local authority. We're going to look at the law, the various guidances and handbook, and various court decisions. The independent reviewing officer, who we will refer to as the IRO, in any case involving a looked after child, performs a vital role to ensure the local authority is a good corporate parent, that appropriate care plans are in place, and that these are effectively implemented in a timeous fashion. The IRO is responsible for monitoring a local authority's review of its care plan with the aim of ensuring that actions required to implement the care plan are carried out and outcomes monitored, and that the review of children's cases and that this regulation, the review of children's cases, open brackets, amendment, close brackets, open brackets, England, close brackets, Regulation 2004, gives the IRO a new power to refer a case to the Children and Family Court Advisory and Support Services, otherwise known as CAFCAS, to take legal action as a last resort where the child's human rights are considered as breached. The appointment of an IRO in respect of every child a local authority is looking after is a statutory requirement. For example, in Section 25A, Children Act 1989, the functions of an IRO are set out in Section 25B of the 1989 Act, which provides as follows. 1. The independent reviewing officer must, open brackets, close bracket A, monitor the performance by the local authority of their functions in relation to the child's case. Open bracket, close brackets B, participate in accordance with regulations made by the Secretary of State in any review of the child's case. Open brackets, close brackets C, ensure that any ascertained wishes and feelings of the child concerning the case are given due consideration by the local authority. Open brackets, close brackets D, perform any other function which is prescribed in regulations made by the Secretary of State. Subsection 2. An independent reviewing officer's function must be performed A, open brackets, close bracket A, in such manner, open brackets, if any, close brackets, as may be prescribed in regulations made by the Secretary of State, and, open brackets, close brackets B, having regards to such guidance as that authority may issue in relation to the discharge of those functions. Subsection 3. If the independent reviewing officer considers it appropriate to do so, the child's case may be referred by that officer to, open brackets, close bracket A, an officer of the Children and Family Court Advisory and Support Service. Open brackets, close brackets 4. If the independent reviewing officer is not an officer of the local authority, it is the duty of the local authority, open brackets, close brackets A, to cooperate with that individual and, open brackets, close brackets B, to take all such reasonable steps as that individual may require of them to enable that individual's functions under this section to be performed satisfactorily. Other provisions worth bearing in mind also include care planning, placement and care review regulation 2010, the relevant regulation relating to the function and duties of an IRO are set out in regulations 36, 37, 45 and 46, which provides as follows. The IRO must, open brackets, close brackets A, so far as reasonably practicable, attend any meetings held as part of the review, open brackets, the review meeting, close brackets, and if attending the review meeting, chair it, open brackets, close brackets. B, speak to the child in private about the matter to be considered at the review unless the child, being of sufficient understanding to do so, refuses or the IRO considers it inappropriate, having regards to the child's age and understanding. Open brackets, close brackets. C, ensure that, as far as reasonably practicable, the wishes and feeling of the child's parents, or any person who is not child's parent but who has parental responsibility for the child have been ascertained and taken into account. And, open brackets, close brackets. D, ensure that the review is conducted in accordance with this part, and in particular, 1, or open brackets, close brackets, 1, that the person responsible for implementing any decision taken in consequence of this review are identified, and 2, that any failure to review the case in accordance with this part or to take proper steps to implement decisions taken in consequence of the review are brought to the attention of an officer at an appropriate level of seniority within the responsible authority. 2. The IRO may, if not satisfied that the sufficient information has been provided by the responsible authority to enable proper consideration of any of the matters in Schedule 7, adjourn the review meetings once for not more than 20 working days, and no proposal considered in the course of the review may be implemented until the review has been completed. In relation to the IRO, the responsible local authority must, open brackets, close bracket, A, make arrangements to implement decisions made in the course or as a result of the review, and, open brackets, close brackets, B, inform the IRO of any significant failure to make such arrangements or any significant change of circumstances occurring after the review that affect those arrangements. The IRO must ensure, that's in section 1 or paragraph 1, the IRO must ensure that, having regard to the child's age and understanding, child has been informed by the responsible authority of the steps child may take under the 1989 Act, and in particular, where appropriate, of, open brackets, close brackets, A, child's right to apply with leave for a Section 8 order, open brackets, residence, contact, and other orders with respect to children, close brackets, and where the child in the care of the responsibility where the child is in the care of the responsible local authority to apply for the discharge of the care order, and B, the availability of the procedure established by them under section 26 subsection 3 subsection 1 for considering any representation open brackets including complaints close brackets the child may wish to make about the discharge by the responsible authority of their functions, including the availability of assistance to make such representation under section 26 subsection A subsection 2 open brackets advocacy services close brackets. If the child paragraph 2, if the child wishes to take legal proceedings under the 1989 Act, the independent reviewing officer must, open brackets, A, close brackets, establish whether an appropriate adult is able and willing to assist C to obtain legal advice or bring proceedings on C's behalf and, open brackets, B, close brackets, if there is no such person, assist the child to obtain such advice. 3. In the following circumstances, the IRO must consider whether it will be appropriate to refer child's case to an officer of the Children and Family Court Advisory and Support Services. Circumstances 1 or A. In the opinion of the IRO, the responsible authority have failed in any significant respect to 1. Prepares the child's care plan in accordance with these regulations. 2. Review child's case in accordance with the regulation or effectively implement any decision taken in consequence of a review or are otherwise in breach of their duties to the child in any material respect, and B, having drawn the failure or breach to the attention of the person at an appropriate level of seniority within the responsible authority, it has not been addressed to the satisfaction of the IRO within a reasonable period of time. 4. When consulted by the responsible authority about any matter concerning a child, or when informed of any matter relating to a child in accordance with these regulations, the IRO must A. Ensure that the responsible authority have ascertained and, subject to the child's age and understanding, giving due consideration to child's wishes and feelings concerning the matter in question, and B. Consider whether to request a review of the child's case. There are regulations stipulating also that the IRO must be registered as a social worker in a register maintained by the General Social Care Council or by the Care Council for Wales under Section 56 of the Care Standard Act 2000, subsection 1, or in a corresponding register maintained under the law of Scotland or Northern Ireland. The IRO must have sufficient relevant social work experience with children and families to perform the function of an independent reviewing officer set out in section 25B subsection 1 close bracket and under these regulations in an independent manner and having regards to the child's best interest. The responsible local authority must not appoint any of the following as the IRO. A. a person involved in preparing child's care plan or the management of the child's case. Child's personal advisor, a person with management responsibilities in relation to a person mentioned in paragraph A to C, or a person with control over the resources allocated to the case. We shall now turn to the IRO handbook. The government issued guidance for IROs, independent reviewing officers, in the form of the IRO handbook. There are many provisions in the handbook. In this particular discussion, we're going to refer to paragraphs 1.12, 1.12, 2.8, 2.10, 2.15, 2.18, 3.39, 3.65, 3.73, 6.3, 6.4, 6.5, 6.13, and 6.14, which provides as follows. The IRO's primary focus is to quality assure the care planning and review process for each child, and to ensure that his/her current wishes and feelings are given full consideration. To be successful, the role must be valued by senior managers and operate within a supportive service culture and environment. An effective IRO service should enable the local authority to achieve improved outcomes for children. Independent reviewing officers then are well placed to assess the quality and effectiveness of local authority planning and support for children. The IROs has a crucial role to play in ensuring that the local authorities fulfill its responsibilities as a corporate parent for all the children that it looks after. The IRO should ensure that the child is offered stable care that is sensitive and appropriate to each individual's personal needs, so that the child is able to flourish and achieve. The plan for each child must demonstrate how the services provided have fully taken account of the child's wishes and feelings. The primary task of the IRO is to ensure that the care plan for the child fully reflects the child's current needs, and that the actions set out in the plan are consistent with the local authority's legal responsibilities towards the child. As corporate parents, each local authority should act for the children they look after as a responsible and conscientious parent would act. The role of the independent reviewing officer is a specialist role which stands alone in the local authority. It is a role that may involve challenging senior managers and may require the IRO to seek legal remedies if the local authority fails in its duties. The independence of the IRO is essential to enable him or her to effectively challenge poor practice. The regulations do not prescribe the position of the IRO within the local authority, but do prescribe minimum levels of independence. The IRO is responsible for setting any remedial timescales. The IRO is responsible for setting any remedial timescales if actions have not been taken and there is a risk of drift in the delivery of a plan that will meet the child's needs and planned outcomes within the child's timescales. In addition to advising the child of his/her rights to make application to the courts, the review must consider whether there should be any change to the child's legal status. The IRO should read all the assessments that have informed the current legal status, including the core assessment, and be satisfied that the child's welfare continues to be safeguarded and promoted by this status. If the legal status of the child appears to be no longer appropriate, the IRO should request confirmation from the social worker and their manager that the local authority has given due consideration to the issue, and if the response to this is not satisfactory, he or she will need to resolve, that is, the IRO will need to resolve the issue through other routes or through implementation of the local dispute resolution process. The IRO must identify the person responsible for implementing the decisions, and the independent reviewing officer must alert the accountable manager to any failure to take proper steps to implement decisions. The IRO has the power to refer the matter to CAFCAS at any point in the dispute resolution process. Open brackets, Regulation 45, close brackets, and may consider it necessary to make a concurrent referral to CAFCAS at the same time that he or she instigates the dispute resolution process. The individual IRO is personally responsible for activating the dispute resolution process, even if these steps may not be in accordance with the child's wishes and feelings, but may, in the IRO's view, be in accordance with the best interest and welfare of the child, as well as his/her human rights. There will be times when the independent reviewing officer may be advised that obstacles in the way of resolving the issue are outside or beyond the control of the local authority. For example, in relation to staffing, interagency or resources issues. However, if these are impacting on the ability of the department to meet the needs of a child as identified in the child's care plan, the IRO should continue to escalate the issue. Each local authority should have a system in place that provides its independent reviewing officers with access to independent legal advice. The reason for this is that the independent reviewing officer, the IRO's works within a complex legal framework with a number of other professionals and adults who have access to their own legal advice. The IRO may feel isolated and vulnerable in this position. It is essential that the IRO too can access independent legal advice, in addition to seeking the advice and support of the IRO manager. In the past, some local authorities have been of the view that CAFCAS duty lawyers provides this service. However, CAFCAS duty lawyers can only provide guidance, not legal advice. Other local authorities have considered it sufficient for an IRO to seek advice from its own legal department. This is clearly not independent. It is important that this service is easily accessible by individual IROs, and that IROs do not have to struggle to access it. We're now going to look at a number of judicial decisions or court decisions. First, we're going to look at a matter which came before Mr. Justice Mumby. It's a case called in the matter of the Human Rights Act 1989, brought on behalf of S, a child, acting by the official solicitor against Rochdale Metropolitan Borough Council and also against the independent reviewing officer. The proceedings were initiated by the official solicitor on behalf of a child in the care of a local authority alleging serious breaches of duty on the part of both the local authority and the independent reviewing or reporting officer, infringing the child's right under the Human Rights Act 1998 and certain articles of the Conventions for the Protection of Human Rights and Fundamental Freedoms. The nutshell of the issue is that the official solicitor on behalf of the child alleged specific social services failing, and I will just mention a couple before I go to the court's decision. One of the issues raised was that at no point during the period of accommodation was the case allocated to a qualified social worker. Then another point raised was that the trainee social worker appointed for the child had no adequate social work experience in child protection issues or understanding of the available legal options which might promote the child's welfare. Another issue raised was that there are no remotely adequate record detailing the training the social worker has obtained, that a competent and experienced social worker would have identified the need for child protection measures and instigation of court proceedings to ensure the safety of the child. And there are a host of other issues which were raised, but the issue was that there were human rights allegations made against the IRO, and rightly so, the local authority accepted responsibility for the role of the IRO. The particular complaint against the IRO was that the IRO, the independent reviewing officer, one, failed to ensure the appropriate education provision was identified for the child, failed to ensure that there was an adequate health plan for the child, failed to allocate timescale for carrying out recommendations, failed to be sufficiently active in ensuring the implementation of the child's care plan, failed to involve senior social worker, where it ought to have been abundantly clear that the trainee social worker was uh, that the child was suffering continuous emotional and physical and sexual harm whilst being a looked after child, among other issues which were raised. The court found the allegations proved, and the local authority accepted that it was vicariously liable for the independent reviewing officer, and the local authority in this particular case entered into a compromise agreement on behalf of the child, and damages were awarded accordingly. And the name of the case again is the name of the case is S open brackets a child acting by the official solicitor close brackets versus Rochdale Metropolitan Borough Council, and the independent reviewing officer reported in 2009 1 FLR from page 1090. That's 1090. In the Rochdale case, just before I move on from it, it's worth mentioning that the court inserted several key information or guidance in the judgment to the address to local authorities generally. And I will quickly touch on this point before I move on to my next case, dealing with the role of the IRO. In one of the appendices to the judgment, it states as follows. 1. Whilst the circumstances of children accommodated pursuant to Section 20 may not justify public law intervention, they should not be regarded as automatically less complex. Time should be taken at the outset to identify the child's need and ensure that appropriate qualified staff are allocated. 2. Line managers should keep in constant review the suitability and experience of the allocated worker as the case develops, and assess whether he or she remains appropriate under the case. 3. An up-to-date case note should be regarded as essential in every case. This is particularly important as staff turnover can be very high in social services, and any new appointee should be able to see at a glance, or at least reasonably quickly, the current issues in the case as well as its history. 4. Statutory reviews of looked after children must be rigorously conducted. Where action of assessment is recommended, time limits should be set to ensure compliance with a named individual identified to put the plan into action. 5. Thought should be given in the case of every looked after child as to whether reviews of the child's circumstances should be held more frequently, particularly at times of crisis for the child. 6. Where parents are not cooperating with the local authority or where they have disengaged, time-limited action should be established to encourage them back to the process. Where this is unsuccessful, with the consequence that nobody is effectively exercising PR, that is parental responsibility, serious consideration should be given to instigating care proceedings in order that the local authority can assume parental responsibility for the child. Indeed, where parents have withdrawn engagement, public law proceedings should usually follow in order that a children's guardian can protect the child's interest. 7. A personal education plan is an integral part of any care plan. The key 8. The key worker should coordinate in a proactive manner all the available information in relation to a child. 9. Any assessment or important information should be made available to the IRO sufficiently in advance of a statutory review to provide him or her with the opportunity to consider them fully. 10. Where a recommendation is made or has been made earlier and there has been a failure to comply, the IRO should be proactive to ensuring compliance with timetables, bearing in mind his obligation to make a referral to CAFCAS if he feels a child is not being sufficiently protected. We're now going to look at the case of Herefordshire Council versus AB, reported in 2018, EWFC, from page 10. The brief fact of this case relates to two children, A and B, who were made subject of care and placement orders in favour of Herefordshire Council. The children's case had not been satisfactorily reviewed for over a period of 10 years, and the matter came for a hearing in 2018. Immediately, the local authority conceded that the serial failures in the care provided or not provided to the children amounted to breaches of their respective Article 8 rights. We're now going to look at how this affected the independent reviewing officer involved with the children. From the time the children were made the subject of care orders and placement orders in 2008 until 2018, the local authority had 8 different independent reviewing officers responsible for the oversight of these children's care plans. The children were initially placed for adoption, but no steps were taken to revoke the placement order for a significant period. And when this matter came before the court was very troubled by the failure of the local authority to apply for revocation of the placement orders when or after the care plans were changed from one of adoption to long-term foster care. Further, there appeared to be no action having been taken from 2009 by the independent reviewing officer in respect of 1. The lack of any coherent care planning for either child, or 2. The failure of the local authority to make application to revoke the placement orders. An analysis of the papers filed on behalf of the local authority revealed that the IRO indeed raised the issue of a failure to apply for or to seek revocation of the placement orders with senior managers within the organization. Despite the best endeavors of the IRO, the application to revoke the placement order was not made for a significant period of time. The conclusion of this particular case was that the local authority accepted that it failed both children in the errors made by the social worker and their managers over a very prolonged period of time. The the independent reviewing officer failed them on a serious and serial basis. The court ruled that the clear message must go out that independent reviewing officers serve a vital and essential function to ensure that a child or a young person's interests are met post the making of a care order or other orders. If those functions and roles are not exercised in a clear, robust, and untrammeled fashion, the children or young person will suffer. We shall now turn to the case of S, open brackets, recognizing the role of the independent reviewing officer, open brackets, IRO, close brackets, reported in 2018, EWFC, from page 71. The brief fact of this particular case is that the court was concerned about the welfare of a child who was age 2 at the time, and the child had been placed in the care of the maternal grandparents, who we shall call GM and GF, under the terms of a care order granted to the local authority. The local authority gave notice of its intention to remove the child from the grandparents, and subsequently, during the course of those proceedings, made an application for a placement order. The local authority raised concern about the condition that in the home with the grandparents, and thus that led to the fostering panel refusing to approve the grandparents or to reapprove the placement, which now required that the children be moved elsewhere. The independent reviewing officer visited the child and the grandparents, and the IRO raised concerns, which in a nutshell was that the IRO did not agree with the removal of the child from the care of the grandparents, and this escalated to the IRO raising a formal escalation under that local authority's policy for dispute resolution. There were also discrepancies as to what the family support worker had reported about the family home and what the independent reviewing officer witnessed when the IRO visited the child whilst in the care of the grandparents. In this particular case, the court made substantial references to the role of the IRO as governed by the IRO handbook, as outlined in paragraph 2.10. The primary task of the IRO is to ensure that the care plan for the child fully reflects the child's current needs and that the actions set out in the plan are consistent with the local authority's legal responsibilities towards the child. The family support worker had prepared a report which highlighted very, shall we say, which described neglectful environment in the home of the grandparents. And subsequently, the IRO and the guardian also visited the home to see the child. And both IRO and the guardian were of the view that the IRO was of the view that the child had a strong attachment to her birth family, and this will stand her in a good stead in forming new attachment if she were to be moved. Whilst this may be the case, it is nevertheless entirely reasonable to assume that a 3-year-old will find it difficult to understand why she has been removed from the only family and carers that she has known from birth. The child's mother is subject of a negative parenting assessment. There is no other family member who could meet the child's need apart from the grandparents. The court was satisfied. The court was satisfied that the care plan now agreed between the independent reviewing officer and the child's guardian within the proceedings was one which could now satisfy the child's emotional and physical needs whilst remaining in her grandparents' care. And thus, the local authority, the court gave permission for the local authority to withdraw its application for a placement order and permission to the mother to withdraw her application for an order discharging the care order. So this case again illustrates the role of the IRO, particularly where the view of the IRO differs from the view of the assessing social worker. In this particular case, differs from the role, from the decision to remove the child from the care of the grandparents. And the matter went into proceedings, and the guardian and the IRO were vindicated, and the child remained in the care of the grandparents. We shall now briefly consider the role of the IRO to monitor the court orders and decisions made within care proceedings, particularly to ensure that timescales are being adhered to. In the case of we're going to look at the case of London Borough of Haringey against Musa. That's MUSA. That's London Borough of Haringey versus Musa, reported in 2014, EWHC from page 1341. We're going to go straight to the decision of the court because I believe that's where the key information is. In this particular case, the judge stated that the dealing with the role of the independent reviewing officer, the court was quite concerned that for reason which was not clear, the contact had been stopped for some significant period of time. Contact between the child and parents had been stopped for a significant period of time, and it is true that the minutes then record that the IRO will ask that it start again, but they go on clearly to contemplate that contact will take place again and then a farewell contact arranged. So the question inevitably arises, how was it that the independent reviewing officer, whose statutory duty was to monitor the performance by the local authority of their function in relation to these children, was not saying loud and clear at the meeting and subsequent to the meeting that there could not lawfully be a farewell contact unless and until this matter had been raised with the court. Instead, the minutes of meeting record that the IRO is in agreement with the plan. It is fair to say that the judge was not impressed that the IRO failed to give to all the children the protection which her role was intended to afford. The judge went on to say that The whole point and purpose of the system and machinery of independent reviewing officer is precisely to keep the local authority, who are no doubt extraordinarily busy and overworked, on their toes and to be asking awkward questions. An independent reviewing officer clearly had been appointed in relation to all children. And from the indication of the judgment, it would appear that the IRO needs to be made aware of court decisions within proceedings so that they can be reviewed at various LAC reviews as to compliance, and for the IRO to scrutinize the non-compliance to ensure that matters are within the court timetable. We shall now turn to the case of X open brackets discharge of care order number 1, reported in 2014 EWFC, from reported on the 3rd of December 2014. From page B217. The significance of this case is that an IRO can be called to give evidence. And in this particular case, the independent reviewing officer was invited to give oral evidence during the final hearing. And the independent reviewing officer had to file a statement in advance of the hearing. For the purposes of brevity, I will not go into the detail of the case, but suffice it to say that independent reviewing officer need to be alert to the fact that they may be required to file a statement and to attend a final hearing in children proceedings. During cross-examination, the independent reviewing officer gave evidence to the following. The IRO accepted that his role meant that he had responsibility for 1. Providing independent oversight of the local authority's care plan, 2. Ensuring the children's interests were protected throughout the care planning process, including court proceedings, 3. Establishing the child's wishes and feeling. The IRO accepted the statutory requirement of the LAC review process, and that as an IRO, he was responsible for setting a remedial timescales where necessary. Again, in this particular case, the court went on to say that the independent reviewing officer is intended to be a robust mechanism designed to hold a local authority to account in the management of a child's plan. In this case, the opportunity to impose remedial timescales to escalate inaction and delay were not taken. So it seems that from this case that the role of the IRO includes keeping an eye on court's decision within care proceedings to ensure the care plan is being progressed in accordance with the court timetable. And where there are slippages, it is the role of the IRO to impose remedial or to ask for the timescales to be remedied. In other words, to impose remedial timescales and to ensure and to escalate inaction and delay where they're not being taken. I will also briefly draw your attention to the case of R open bracket revocation of placement orders colon unacceptable delay close brackets reported in 2014 EWFC from B175. Basically, the issues arising in this case is also similar to the one we looked at previously, where there were inordinate delay, and the court took the view that it was the role of the independent reviewing officer to ensure that the children's case were kept under review to avoid or which could have prevented inordinate delay in the children's care plan. I think we should just look at one more case on this subject, and finally we're going to look at the case of Lunenburg Brent versus C, reported in 2016 EWHC from page 1335. I will only deal with the aspect of the case which affects the IRO. In a nutshell, proceedings had been commenced, and there were alleged breaches of the human rights of the child. The law number of Brent admitted that they had erred in the case by not applying for care order far sooner, that they should have done it a lot earlier than they did. And as soon as it became apparent that the child could not be adopted and that the child was seriously sick, requiring medical treatment. In this particular case, the court went on to say that there were again inordinate delay in issuing proceedings to safeguard and protect this vulnerable child. Without going into the full facts and full details of the case, suffice it to say that a human rights application was launched against the local authority for breach of the child's human rights, and the court indicated that the independent reviewing officer, whose function and duty it was to provide an independent safeguard for the child, failed to do so by failing to take any step to ensure that the local authority did apply for a care order or otherwise regularize the position. These failures did, as the local authority and the independent reviewing officer both readily admit, amounts to acting or failing to act in a way which was incompatible with the right of the child under Article 8 of the European Convention on Human Rights. And in this particular case, the court went on to declare the failures on the part of the local authority and the independent reviewing officer, and it states as follows. 1. The London Borough of Brent acted incompatibly with the child's Article 8 rights by delaying in allowing him to have access to judicial scrutiny, legal advice, and the children's guardian about his family situation. 2. The independent reviewing officer acted incompatibly with the child's Article 8 right in that she failed, 1. to identify the above infringement of the child's human rights by the local authority, 2. fail to take effective steps to resolve the human rights infringement, and 3. fail to refer the child's circumstances to Kafka's legal. The court also expressed its concerns as to the position in relation to the child, and that the independent reviewing officer and the local authority continue to approach the child the mother, who was a 13-year-old child herself, for agreement as to medical procedures. And the court was quite critical of that particular local authority as to the role of the independent reviewing officer.